The cloud. Okay. So next week is your exam. It's your second exam. It's going to conclude with the hello. It's going to conclude with the material that we finished today, which is going to be chapter 18. So we really started with contracts in chapter 9. So it's from 9 to 18. It's actually, like I said before, it is the shortest amount of material, but we go into detail, a lot of detail with things. So make sure that you understand the material itself. Again, the exam is going to be open book. I started drafting the questions for the exam. So tonight, especially, if I'm harping in on something, certainly pay close attention to it. It's looking like it's going to be 20 multiple choice questions and 10 true and false, and maybe a few, maybe 2 or 3 extra credit. I'll give you the opportunity to go past the 100 points. That way, if you get 105, maybe maximum, or 109 or 110, it also helps boost up your grade for that point. Today, we're going to go over chapters 15, 16, 17, and 18. One of the chapters is relatively short, and I expect to be finished, in pretty good time for the evening. So again, if you have any questions, you can stop me, or from now until next week, you can email me questions, if there's a concept that you don't particularly understand. Okay. And again, also for the exam, it's going to be posted on Blackboard next week, Monday at 6:30 p.m. You'll be able to access it. You're only going to have one shot. Okay. I do like you can get a second shot to do it kind of thing on the first exam, because it's really our first time together. But, next week you're going to have one shot. So make sure your internet works. Make sure that you don't submit unless you're sure, because that's it. Like, I can't go back and just modify it for one student to allow you to retake it if it just ended by itself. I don't, I It's going to be one shot and that's it. So we'll get started with chapter 15. Again, we're continuing contracts. And what chapter 15 focuses on is on contracts that must be in writing in order for them to be enforceable. So we spoke about, whether or not an oral contract is enforceable. And I remember, if I asked you, how many of you think an oral contract is enforceable? And usually, some say yes, some say no. But I always tell you, the answer is really depends. It depends on the situation, it depends on the circumstances. And there are, by law, right, by statute, there are some contracts that must be in writing. Otherwise, they're not valid. You're not going to be able to enforce them. And when we talk about those types of contracts, there's a couple that I want you to know. And there's a couple, I think the book gives you 5. I'm going to tell you about the 5. This is something that I'll tell you when to write it down, okay? When you are considering marriage, right? Marriage, I told you before, it's a contract between 2 people, right? That's essentially what it is. And so a marriage must be in writing in order for it to be enforceable, in order for it to be a contract. That's number 1 that I want you to know. Number 2 that I want you to know. This is a write it down stuff, okay? When we talk about interest in land, when we talk about real property, when we talk about the sale of real property, that must be in writing in order for it to be enforceable. If it's not in writing, it's not good. Okay. And then the last thing is contracts that are going to take longer than a year to be enforced. That also has to be in writing. That's the trickiest one, really. So contracts that are going to be performed, if you're doing an employment contract with somebody and you're hiring them on for more than a year, that must be in writing in order for it to be enforceable. If you're going to be asking somebody to perform some kind of service for you for more than a year, that must be in writing. Um, Again, if you're renting out a piece of property. Now, when we're talking about renting, it's the lease. So does that have to do with real property? It's not the buying and selling that is of interest here. It's actually the lease agreement. And the subject of that, if it's 6 months, does it have to be in writing? No. Do I strongly recommend that it's in writing? Yes. But the law says agreements that are going to be taking more than a year must be in writing in order for them to be enforceable. Okay? Any questions on these things before I go on to the next concept? Going once.
Professor?
Yes,
Hi, I have a question. So,
sure.
basically, you said the marriage, then interest, the contracts, which takes longer for a year, must be in writing.
Yeah.
But I didn't get this last one.
Agreements not to
So
be
basically,
performed within.
the lease. So basically, if the contract is going to be for less than 6 months or less than
Less
one
than a
year, could
year.
be
Less than a year.
less than a year.
So yeah, I was giving if you're gonna hire somebody, to work for you for 11 months or 10 months for seasonal, right? Like a seasonal, like for Halloween season or whatever. Do you need to have that in writing? You don't need to, because
Hmm.
it's going to be only done for that one particular season. If a
Hmm.
contract cannot be performed in less than a year, by its very nature, it must be in writing in order for it to be enforceable.
Oh, I got it. Thank you.
You're very welcome. Okay. Um, there's other things also that I'm going to tell you. These are listening ones. If you are answering for the duty of another, that also must be in writing. What does that mean if you're answering for the duty of another? Let's say A and B enter into a loan agreement with one another, right? Let's say you are all students and you have student loans from, a bank. And so the loan agreement is actually between you and the bank. If your parent, if your brother, if your boyfriend, if your girlfriend, if your spouse is going to come in now and pay those installments on your behalf, that actually needs to be in writing with the bank in order for that person to be a third party. So if somebody's stepping into your shoes and taking on that loan, that has to be in writing. Otherwise, it's not good enough. So when somebody's answering for the duty of another, that must be in writing. And then the other one that the book mentions is when we have an executor or an administrator, basically like when somebody passes away and there's somebody now that's going to be managing their estate, a fiduciary, that must be in writing in order for that also to be enforceable. So somebody can't say, oh, I know that my dad designated me to be in charge of his or her estate when they die. That's great that they may have told you that, but unless it's in writing, unless there's a will but then gets proven by the court, unless the court issues out a document that says you are in fact in charge of that estate, you can say whatever you want, you can believe whatever you want, but unless it's in writing, it's not going to be good enough to give you that fiduciary standing. Okay. Blah 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 blah. Let's see here. Okay. Um, okay. This is the other thing I want you to know, and this is a write it down. If you're purchasing something and the value of it is more than $500, that must be in writing in order for it to be enforceable. Okay, so write that down. If you're purchasing something and the value of it is more than $500, that must be in writing in order for it to be enforceable. Okay. Um, okay. Who wants to tell us about the estate of Jackson versus Devens?
I could say something about it.
Okay, great. Thank you.
It was about George Jackson and his neighbors drafted and signed a document about a 79-acre parcel,
Mm-hmm.
and Jackson supposedly allocated 1.3 acres to himself. And when he died, his estate refused that, and they decided not to honor the agreement.
Okay. And do you remember what the court said? I know that it was appealed and then it went back to the court. Do you remember what the ultimate outcome? What's the point of this case? Let's say I was to ask you, for instance, what is this case about? What is the legal concept here that we're learning about? What would that be in this case?
The document was unclear.
Mm-hmm. Yeah.
Basically, the parole was like there were like no like clear evidence or something like that to understand the ambiguous term. So
Right.
I think it was like dismiss something like that.
Right, because see, they had this oral agreement as to the actual property and how far it was going to go, but because it wasn't in writing,
Yeah,
it wasn't specific enough in writing, it wasn't good enough. If
because the court said basically that it could be like fraud, because it wasn't like something that it was clear because it wasn't
exactly. Yeah,
writing on like that.
it wasn't in writing. Does anybody here own a home? Or
Yeah, I do.
okay, I want you to look at, or if you could recall, when your deed to the property. So not only it gives you the address in the contract, right? It tells you what the address of the property is. Does it tell you anything else, the deed itself? Do you recall?
Basically, it tell like the number, like the contract that is like the number of the file where it's registered. And it told me like my address and it tell my name and
Right, but there's
on their
actually more
whole,
stuff.
yeah, like what jurisdiction they can, like all those kind of things.
It has, yeah, it has like, there's actually point, longitude and latitude of points of exactly where your property starts and where it ends. So we don't all have pieces of property that are perfect squares, but it'll tell you, like it's at, 95 latitude, 38 longitude here, and then it goes to the 34th point to the 68th point here, and blah, blah, blah. And it has such detail. Why? Because it specifically draws out where the land is.
Yeah,
You have,
actually, like I had a problem because I had this house in my country. I'm from Venezuela, and basically we were trying to sell this house because we were moving to somewhere else.
mhm,
When we were trying to sell the house, we figured that we like our house was bigger than what we thought. So basically, our neighbor took one part of our house. So we took this to the court and all those kind of things, and they basically like let us take our piece back. So that's when we noticed that, oh look, like we were having like, for example, like
yeah.
200 feet and the contract was like 250. So like
And
they were,
that's a big difference.
yeah,
That's a huge
and
difference.
they actually like in the court, like they evaluated. It took like year and a
Yep.
half, and they are like, and then after they say that it was ours. So because it was in the contract and everything was like perfect.
Yeah. No, no, see, it's very interesting, and I'm gonna bring some world, you're talking about a piece of property that was in Venezuela, right?
Yeah,
There are, if you now I'm really focusing just on, the United States and pieces of property here, but I want you to think and just take a moment to think about historical disputes between countries. Okay? It's always, not always, right? There's other things too, but you have predominantly there's issues of land ownership, right?
yeah,
You have, let's say, look at between in the Middle East, right? Israel and Palestine. It's about land ownership. Look at what's happening today, which maybe you don't even know about it. Look at what's happening in Armenia and Azerbaijan, right? Over that other piece of property in, I think it's called Artsakh, right? They're fighting over,
It's
uh,
called Artsakh.
thank you, it over this middle piece, right? But one side says this has always been ours, under our control. It's actually an independent place, and the other side saying no, it's being occupied. It's about land ownership. Now let's bring it to something more common that you've probably heard of. You've probably heard of neighbors fighting over their fences, where fences should be in yards. That's because sometimes somebody will have a fence and their neighbor doesn't say anything. You have a new owner that comes in, and the new owner is like, "Hey, my property's actually on this piece. You've taken 6 inches. You've taken a foot from my land." And so that's why you'll have disputes. So when we talk about this particular case, Jackson, it is about real property needing to be in writing in order for it to be enforceable. So contractual agreements with land must be in writing in order for them to be enforceable. Okay? Okay, great. So also in chapter 15, we also talk about the sale of goods. And Article 2, this is a listening thing. Article 2 in the UCC says that, when two entities are, again, reviewing things or selling or buying things, that again must be in writing. there is we talked about the theory of promissory estoppel before, right? You should know what that is. I'm going to repeat it again. And promissory estoppel, this is something you need to know. It's when there's an oral contract, but the court says, even though this was an oral contract, when one party justifiably relies on it, the court will enforce it to avoid injustice. Do you remember what case we read that had to do with promissory estoppel?
Yeah, I believe in Skeba
Yes.
versus Cash.
Yes, excellent. Very good. Excellent. Very, very good. Promissory estoppel is that case. Now, there's another legal theory that I want you to know and you need to know for the exam, and this is the parole evidence rule. And the parole evidence rule says that when two entities agree in writing, right? You are probably negotiating back and forth. You have offers, you have acceptance, you're tweaking this, you're tweaking that. A lot of times in actual contracts, you're going back and forth. The parole evidence rule says that the contract, the four corners of the document, are exactly represent all the terms of the agreement between the two parties. So let's say you had some kind of side deal going on, and you based your understanding on that side contract. If it's not written in this main agreement, it doesn't mean anything. Let me give you a real life example. Let's say you see a house on Staten Island that's worth $1.1 million. If you pay over $1 million for a piece of real property, you have to pay an extra tax called a luxury tax. Let's say you get into an agreement with the seller, buyer and seller get into an agreement that say, you know what, let's put it down on paper that I'm going to pay $950,000, even though I'm willing to pay the 1.1 million, but I'll pay you the extra 150,000 in a separate agreement. I'll just give it to you in cash because I don't want to have to pay any extra taxes on that. So the agreement in principle, it's oral, it's going through. Now it's time for the seller. He agrees to this. He gets his $950,000. And he's like, hey, where's my other 150,000? Now you, as the buyer, you could be like, I don't know what you're talking about. But you agreed to this, but it wasn't actually in writing. The contract that you entered into as the seller only says a purchase price of $950,000. So if you go to court and you try to enforce this outside agreement that you had, the court's going to say, look, I have a piece of paper here. And this piece of paper says you agreed to $950,000. You trying to get into some kind of side agreement, even though it was to help the other side, there's nothing here that reflects that. So I, as the judge, as the court, have to look at the four corners of the document and interpret it for what it is in order for it to be enforceable. So that is the parole evidence rule. Okay? Okay, great. That concludes everything for chapter 15. I'm going to move on to chapter 16. So chapter 16 is relatively straightforward. Only a couple of things I want you to know. Chapter 16 deals with third-party contracts. Third-party contracts. That's when, again, you have an agreement between two people, two parties, and now you're bringing in a third party into it. How do you bring in a third party? You can do it by one of three ways. The first way is by an assignment. The word assignment should ring a bell to you because we spoke about it when we talked about leases. The second way is delegation of duties. And the third is there's express terms in the contract that allows for a third party. What I want you to know is the assignment. You only need one requirement to have an assignment, and that is intent. Okay, that is intent. So if you are assigning a task to somebody else, that you need the intention must be there. Now, let's explore where we can have an assignment done in a contract and where it would not work. There are certain things that you cannot assign to a third party. Things that are highly personable, you cannot assign. Also, certain things that are actually prohibited from assigning. So, let's go back to marriage. In marriage, we said it's a contract between two people. If A and B agree to marry with one another, can B decide the day of the wedding, you know what? I'm going to assign my contractual obligation to C. Can that be done? No. I'll answer for you. No. If A and B decide to marry, they're entering into a contract of marriage. B cannot assign his or her marriage, obligation or contractual obligation to somebody else to fill in for him or her. That is a highly personal thing. You cannot designate somebody else to marry for you on your behalf. So that's a clear, I would hope this is a very clear-cut one. Now, what about this example? So I want you to think about it, and then I want you to tell me whether or not you can assign this or not. I have a brain tumor. I need surgery done. I do research and I find a brain surgeon that specializes in these types of tumors. I live in New York. This surgeon is in Washington State. I fly all the way to Washington State so I could have the surgeon perform my surgery. We get into an agreement. He or she agrees to do it. The day of the surgery, he or she is not there. They send their partner and a first-year medical student. Can the surgeon that I wanted to perform my surgery designate, assign their responsibility to a different surgeon?
No,
Why not?
because you are looking for him, especially like his
Exactly.
talent.
Exactly. I wanted this particular surgeon to perform my surgery. Now, let me give you another example. I am pregnant. I am 4-month pregnant. I go to an OBGYN so he or she can monitor my progress. When I'm 4th month pregnant, I see Dr. A. When I am 5-month pregnant, I see Dr. A. When I'm 6 months pregnant, I see Dr. B, who works with Dr. A. I see Dr. B one more time, and then for the remainder of my pregnancy, I see Dr. A. It is time for me to give birth. I've seen Dr. A many more times than Dr. B. But Dr. B is the one that's on call the day I go into the hospital. Can Dr. B deliver my baby?
Yes.
Yes.
What's
Yes.
the difference between the second scenario and the first?
Because on the first scenario, you wanted that specific doctor for your brain surgery.
Mhm.
He specialized in that thing,
Right.
but in this scenario, they both can like help you to give a birth,
Right.
and the second doctor may be on vacation or somewhere else,
Right.
so
Right.
he may not be there.
Exactly. So in scenario 2, I saw both physicians. They work together. I'm not in any special need, so any OBGYN physician can assist me, okay? Now, you have this distinction with physicians. I'm going to give you two more examples, not physician related. I've always wanted a family portrait of my family so I can hang it in my living room, right? So again, I seek out a highly trained and highly specialized artist that specializes in blah, blah, blah artwork. I go to him or her and I agree to a contract where he or she are going to paint my photo of my family. I go for my family sitting and he has his understudy or she has her understudy there. Is that acceptable? Can the original painter designate his or her duties?
No, he cannot.
No.
Correct. No. Why? Because it's something personal. I specifically wanted this person. Then I'm going to give you the last example. I got injured. I want Celino and Barnes to represent me. You know who Celino and Barnes are?
Yes.
Okay, or Johnny Cochran, okay? Think of I need a high profile attorney to represent me. I go to this attorney and I give him I sign a retainer with this attorney. He is going to represent me. Let's go with Johnny Cochran because maybe you've heard of him more. So now it is the first appearance of the case to pick a calendar. I go there to the court. I'm waiting to see Johnny Cochran, but he sends his associate there. Is Johnny Cochran sending his associate acceptable to pick calendar dates?
Yes.
Why?
Because it's just to pick the calendar dates.
Exactly. It's just to pick calendar dates. If it was the day of my trial and before a grand jury or before the jury, I would want Johnny Cochran there, not an understudy, not a paralegal, not a first year associate, because it depends on what we need them there for. Okay. So this is all about assignment and intent and what you can assign and what you cannot assign. Okay. So with that, there's one case I want you to know, and that's the case of In Re Magnus. Who wants to tell me about In Re Magnus? Give me the nuts and bolts of In Re Magnus.
It was something with the fancy membership club
Yes.
that they cannot assign like somebody else, the third party, to the membership because they are very wealthy and they check their history.
Right, exactly. Very good. Excellent. It's basically a fancy, prestigious golf club. So if you are a member of a fancy club and you want to assign your fancy club membership to somebody else, you cannot, because fancy clubs get to choose who joins in their fancy clubs. Okay, and that's something I as I grow up, I learned about. There on Staten Island, there are fancy clubs. And so you can't just go in there and be like, oh, I just want to join your club. No, you have to pay money. You have to be admitted. They look into your history. They ask all the other club members whether or not they know you, whether they hate you, what type of person you are. So again, fancy club membership, not assignable. Okay. That's the only things I want you to know for this case. For this chapter, I mean, okay? I'm going to move on to chapter 17. So we have talked about, right, contract, how to enter into them, who can enter, mental capacity, all that good stuff. Chapter 17 focuses on performance, breach, and discharge. So when we talk about performance, it's very clear. When we talk about you performing your end of the contract, it's basically you doing what you were supposed to do. So this chapter gives you a couple of different terminology and explains what they are. So that's what I'm going to do now. So a um, express condition in a contract is just exactly what it says. It is a clear condition, express. It is written there. It is in black and white. It tells you that I'm only going to enter into this contract if so and so happens. There's a condition sometimes. So we, you know what a condition is? I mean that's just basic like English language. So an express condition, I'm only going to go through with this if X, Y, and Z happens. So, for instance, I'm going to buy your car for $5,000 as long as it has less than 10,000 miles on it. So, I'm only going to buy your car for this particular price if this condition is there. It has less than 10,000 miles. If your car the car that I'm purchasing has more than 10,000 miles, I'm not going to be able to, I don't have to purchase it from you. Okay. So my sister uh, entered into a contract to buy a condo recently. And she entered into this contract based on certain representations that were being made to her, that were made to her. It was the condo was supposed to include X, Y, and Z when she did the inspection and then they're like, getting into the details of things, she found out that X, Y, and Z were not part of the a condo, the apartment. So I told her, you can get out of the contract. Why? Because you entered into this agreement based on this particular understanding. If it is no longer valid or that understanding is not actually accurate or true, you don't have to go through with it. You can get out and you're not breaching anything. Why? Because there was an express condition saying that you will enter into this contract as long as this is going on. Okay? So that's express condition. The next concept, I love this concept. I love this concept. This is called the satisfaction of a contracting party. And this is a concept, a legal concept, where if you have it in writing, it depends on which side of the contract you're at. It is a completely subjective test. And so it's mostly put in um, where you have maybe like artwork or certain types of work being done, right? So let me give you an example. If I'm going to pay you, remember that portrait that I said I wanted of my family? And I tell you, I'm going to pay you $1,000 for my portrait as long as I'm satisfied. As long as I'm satisfied. So that me putting in those words, as long as I'm satisfied, that's actually the satisfaction of a contracting party. So you can draw me a wonderful rendition of my family. If I don't like it, I don't have to pay. So, okay, you'll do it again. Great. Do it again a second time, a third time, a fourth time. If I'm not satisfied, I don't have to pay. It's completely up to my taste. They can be wonderful paintings, completely lifelike, completely true, like almost looking like they're pictures. But if I'm not satisfied, it doesn't matter. I don't have to um, pay for it. I don't have to go on with the agreement, right? So you always, if you're entering into a contract with somebody where you're producing something or you're doing some kind of work, make sure that you understand what that really means. Satisfaction guaranteed. What happens if I'm not satisfied? Well, then you can return it for a full refund. That's probably something you hear quite often with products. If you're not satisfied for any reason, return it, you get a full refund. That's the concept of satisfaction of a contracting party. Okay? So that one I want you to know. Next one is a listening one, implied in fact conditions. Those are conditions that are not express but implied, where one party is going to do something. A will paint B's house any color B chooses. Well, A can't paint B's house until B tells A what color it wants. So it's implied that B is going to provide some more information because A is not going to just go ahead and pick any color, A wants to paint. That's not going to work. right? So that's an implied in fact condition. Discharge by performance. Okay, discharge by performance. If you kind of break down the words, it's basically, you performed your contractual obligation and you're done, you're complete. Best example I like to give of that is a mortgage, right? When you're buying a house, chances are you're not paying cash for that house. You're actually entering into agreement with the bank who's going to loan you the money, and then so that's the bank that owns the house until you finish off that mortgage. Well, when you finish off that mortgage, you get a discharge. There's a piece of paper, you are discharged of your obligation to pay the bank. So that's discharge by performance. Discharge by breach, like opposite of discharge by performance. It is when you are did not perform your contractual obligation, and so you're breaching your contractual obligations. So the contract is no longer good, or you're breaching your end of it. So it's discharge by breach. What's going to happen if you breach your end of the contract? There's probably going to be a lawsuit of some sort. Um, well, what kind of breach? When we talk about different breaches, right? Is it a material breach? That's the next thing. You need to know material breach. Material breach is if you don't do something that was substantial that you had to do. Material breach is a big deal. It's a big breach of your obligation. So if I'm making monthly installments, right? That's the deal that I have. I'm supposed to be paying you $100 every month as part of our, contractual obligation, but instead of $100, I paid you $1. Well, I did pay, but I basically, there's a material breach here. I'm supposed to pay you $100. And let's say I don't pay you today and I don't pay you next month, then I'm materially breaching my end of the contract. Why? Because I'm not doing something major. If I paid you $99 instead of $100, I technically breached my contract, but is it a material breach? One could argue that, you know what, it's only $1 short. It's not a big deal. I'm going to put it on to the next monthly installment, right? So next monthly installment, I pay 101. Not a material breach. It is a technical breach, but not a material. It's not a big deal. The next concept is discharge by agreement of the parties. And a discharge by the agreement of the parties, both sides who had entered into a contract with one another say, you know what, it's not working out. We're just gonna, let's just walk away from this. It's just not a good deal for us. It's not a good working relationship. We can just both agree to move on separately with our life. Um, Frustration of purpose, a little more difficult, the concept. And frustration of purpose is you're waiting for something to happen, but it doesn't happen. So you entered into this contract here's an example. Let's say last year you entered into a contract with one of the apartments overlooking the Thanksgiving Day parade. You didn't realize that the world was going to end due to COVID. So you rented out this apartment for the purpose of for a couple of hours so you can watch the Thanksgiving Day parade. Now, the Thanksgiving Day parade is not going to go forward this year. So can you get out of the contract? Well, you can, because you entered into this contract. You're only renting out this apartment for the sole purpose of watching this parade. And this parade is now not going to go forward. Bathroom? Okay, hold on. Oh, hold on. Sorry guys. You can hear my child. He needs to go to the bathroom. Potty training. It's important stuff. Okay. So that's frustration of purpose. Next concept is bankruptcy. Um, you all know what bankruptcy is. You've heard it in all different contexts. Businesses are going bankrupt. People can go bankrupt. It's when you're no longer able to fulfill your financial obligation. And so you can declare bankruptcy where you say, you know what, I cannot pay off all these things. I have a lot of debt that I've accumulated. Judge, I need to kind of clear off in a clear start. It ruins your credit for, 7 years. But you'll have a clear slate. All these creditors are going to be, out of luck, but you're also, it's a way out. if you will, and it's usually a last resort for people. Okay, so that takes care of everything in chapter 17. Are there any questions before I move on to the final chapter of the evening? Okay, chapter 18. Chapter 18 now focuses on remedies for breach of contract. So you entered into the contract, you entered into a contract with somebody over something legal, somebody who's got the mental capacity to enter into a contract with you, but somehow the agreement went south. There is a breach by discharge because one side's not doing what they were supposed to do. So now you are going to be suing in court. What do you think is the most common remedy for breach of contract?
Money.
Money, exactly. It's monetary damages. When you sue, you are suing to get money. But there are actually, and write this down, this is something to write down, the most common remedy for breach of contract is monetary damages. There are others, however, and you need to know those as well, but know that
Can you say it again? And I'm sorry.
Sure. The most common remedy for a breach of contract is monetary damages. So the most common remedy for a breach of contract is monetary damages.
Thank you.
You're welcome. Now, there's other types of remedies as well when you have a breach of contract. The next one I'm going to discuss, it's called specific performance. And specific performance is money is not good enough. I want you to do what you were supposed to do. And let me give you a real life example. So many years ago, I was with a colleague of mine and I was looking at houses. It was before, we moved into the place that we're living in now. And my colleague said my neighbors, there were older people and they passed away and their kids live out of state. They have a beautiful house, and I think it might be going foreclosure. It hasn't actually, like, I don't know if they've been paying or whatnot. Maybe you can look into it. So they got me like the address. I started stalking it online. You can find anything online. The house was gorgeous. It had an elevator in it. It had a pool. It was wonderful. I think like the zest, the what's it called? That's not realtor. The one starts with a Z, Zillow. The Zillow estimate was like 800,000. I'm like, I can probably, if it's a foreclosure, maybe I can get it for like half price, 400,000. Anyway, I started looking into it because there was a case against it in a court, in like Supreme Court. So I'm thinking it was foreclosure. You dig deeper, and I found that it wasn't a foreclosure agreement. It was actually an enforcement of a sale. So the children of the people who owned the house, they lived out of state. They just wanted to get rid of this house quickly. They put it up for a particular price and they did not. So they put it up for a particular price. Somebody came, saw the house, and they entered into a contract for that particular price. The owners, right, the kids of the actual owners realized later that they undervalued the price of the house. So after they entered into a contract for a particular price, they realized that they put it on the market for too low. So they were trying to undo their contract. The people who entered into the contract that wanted to buy this house, they were like, oh, no. We don't want money. We don't want our deposit back, right? We want this house. This is a unique house, and we're not going to be happy unless we get this house. So monetary damages were not going to be good enough for them for this particular house. They wanted to perform and have specific performance. They wanted to enforce the contract of sale that they entered into with this seller. So that's when something like that, you want specific performance. Money is not good enough. The next concept I want you to know is injunction. Injunction's like the opposite of specific performance. It's not when you want to enforce something, it's when you want to stop something from happening. So an injunction is you some kind of action is happening. Let's say your neighbor is building a fence or building a pool or digging underground, and they entered into a contract with somebody else, but it's affecting your livelihood, your land, because it's infiltrating your land, right? You go and you get an injunction because you want them to stop this contractual obligation that they had entered into with another party. So an injunction is you want somebody to stop something. Okay? Those are the three. Your book gives you a couple of more about restitution and things like that, but I just want you to know monetary damages, specific performance, and injunction. Now, when we go back to monetary damages, there's a lot of different ways to calculate monetary damages. I'm not going to ask you all the different ways to do it. I'm going to kind of just give you one example, and I want you to just know this example. But I will tell you, as a listening thing, you can, when you're suing for monetary damages, there's all different ways to calculate loss, and you can add on interest, you can add consequential damages, you can add like punitive damages, depending on the type of case. If you want to like punish somebody, you can add on like there's like something called like liquidated damages. You can, if the contract had gone through, how much you would have gotten. There's all different ways to calculate it, but I'm going to give you an example of how I want you to. It's like a general understanding of this. Okay. So I'm going to share this now that I know how to do this whiteboard thingy. Okay. Share. Okay. So I am a contractor. Actually, I'm not a contractor. I'm hiring a contractor. I'm a builder. I make big buildings and I sell them. So I hire somebody to build this big building. And in this big building, okay, I have a building, as you can see, and it has 6 units. So I'm building a residential house building. It's going to have 6 units. Every unit, if I rent it, and I'm guaranteed I'm going to be able to rent it, I will get $100 per month per unit. So if it's $100 per month per unit, I have 6 units, right? So that's $600 a month, right? So think about $600 a month. And I have a property manager, and I pay the property manager to take care of my property. I pay their company $100 a month. Okay. Now, I hire this person to build this building, and I told this builder I need it by January of 21 because I have already things in place, people that are going to rent it. He's not able to deliver it until June. So it's from January to June. I lose out on January's rent, February, March, April, May. I lose out on 5 months rent. Okay. How much can I sue the contractor for? What's the maximum I can get?
400.
How much?
400.
500 or 400?
4.
Does
400.
anybody else have any other numbers besides that? If I'm going to get $600 a month, if it's rented out, and this guy is 5 months late, how much can I sue the contractor for? How much money would I have made if the building was done on time?
3,000.
Correct.
3,000.
Right. I would have made $3,000, except it wouldn't have all been pure profit. Why? Because I had to pay the property manager $100 every month, but I didn't have to pay the property manager because I didn't have any property to manage. But if I did actually have the $3,000 in rent, I would have paid this person $100. So I would subtract $500 from here. Because if I was in fact renting out this piece of property, all 6 units, I would have had to pay the overhead every month. So I actually lost $2,500. That's how much I would have made in actual profit had I gotten my building ahead of time, like on time, on schedule. Does that make sense?
Yes.
Okay. So I could sue the contractor and recover a maximum of $2,500. That's a fair number. If I got the $3,000, it's actually a windfall. Okay. So that is that. Let's stop sharing here. Okay. So that is that. And let me see here. Okay. Okay. Another way to calculate damages, and I'm not going to ask you to calculate things that way, but it's foreseeability of damages. Whether or not it was foreseeable that this person was going to suffer these damages because our contract did not go through. And the case that clarifies this concept, foreseeability of damages, is Hadley versus Baxter Dale. Who wants to tell us about Hadley? Just as an FYI, Hadley versus Baxter Dale and Parker versus 20th Century Fox are on your exam. So, and after we finish these, couple of points, we're basically done for the night. So, who wants to tell me about Hadley versus Baxter Dale?
I can tell.
Go ahead.
So basically, Hadley owned and operated a corn mill in Gloucester, and that thing it's called crankshaft that operated the mill. It broke, and it needed to be replaced. And in order to get the new one, he had to send the broken one to. He had to ship it to that company, Josie and something. I don't remember the exact name. It's the engineering company in Greenwich. So it can be used as a model for a new shaft. So Hadley contacted a shipping company called Pickford. That's been owned by Baxter Dale, and he obtained to obtain the shipping information for crankshaft. And he's been informed that the crankshaft was delivered to Pickford before noon. It's going to be delivered, and it would be shipped and delivered to Greenwich the following day. And for some reason, it wasn't shipped on time due to the person who worked there irresponsibility, I could say. And that's why it's been shipped a few days later, and he wasn't able to work because of it. And he has some losses as a result. He had some losses. So that's the reason why he sued them, and jury awarded Hadley the lost profits, but Baxter Dale they just appealed this decision. That's in short, I guess.
Okay, and what happened on the appeal? Do you remember who ultimately won here? What did the court say about this case? Why is this case so important, or like what does it teach us?
I kind of don't remember that.
Okay, no problem. Basically, this case said it wasn't foreseeable that the mill was going to stop operating because they didn't have this particular piece. They never notified the person that they were getting it from that if they didn't have this piece, they were going to have to shut down their entire mill. This is a very, very old case. So there was no way for the person providing it or the entity providing it to know that, them being late is going to cause this whole thing to shut down. So it's important to notify if you're entering into a contract and you need something by a certain date, or there's a time of the essence clause or whatnot, you need to notify the other person. You're putting them on notice. That way they can't say, oh, I didn't know, like if it's a day late, if it's 2 days late, unless you let them know, then, and things run late. It's out of their control, right? but you can't sue them for an entire operation shutting down because of this one particular piece. So that's what this case is about: foreseeability of damages. Okay. Good job. The last case that I want you to know, and then we're done for the night, is Parker versus 20th Century Fox. And who wants to tell us about that? Guys, I don't give homework, so the least
I
you
could
can
talk
do is
about it.
read. Excellent. Thank you. Go ahead.
Parker was offered a leading role in Bloomer Girl,
Mhm.
and Fox offered to pay $750 for 14 weeks of work,
Mhm.
starting in March. She received a letter in April that they would not continue the production, and they offered her a different offer for a different film,
Mhm.
and she didn't accept it, and she sued for the first contract for
Right.
$750,000.
And do you know what happened? Do you remember what happened?
She received the money.
She did, yeah. So this is probably one of those cases where I don't agree with the outcome, but nonetheless, that's what happened. And everything you said was correct. What did the court say, if you recall, as to why they gave her the $750,000, even though she didn't do anything? She just got $750,000 because, you know,
Because she could have said like another offers,
correct.
but she didn't because she was already in contract with these people.
Yeah, she could have accepted other offers, and then what was additional is like she couldn't choose who the director was. It was a very different type of movie. The first one was like a, dancing theatrical. The second movie that they offered her the role in was a Western. So that's not what she was known for. So it was considered to be inferior in nature for her. And so she was able to collect on the contract. Why? Because the other side, Fox, breached their end. She had entered into this contract with the understanding that I'm going to be in this, theater. I was going to sing and dance, and it was going to be a musical. And now they want me to go into this Western, which I would have never agreed to. If it was offered to me in the first place. So that's Parker, 20th Century Fox, inferior contract. So she didn't have to perform with it, and she was able to get paid. So she was able to get her money, monetary damages. Does anybody have any questions on anything we covered tonight? I actually, before I forget, let me give you the secret phrase for the evening. Today's secret phrase is, I can't wait to go on vacation. I can't wait to go on vacation. Secret phrase for tonight, I can't wait to go on vacation. Okay, now does anybody have any questions on any of the material that we covered tonight?
Could you just repeat promissory estoppel again, what that was?
Sure. Promissory estoppel is a theory that enforces a non-contractual promise, because not doing so would be an injustice. In plain English, it's enforcing a verbal contract when there should have been a written contract. But because there was justifiable reliance on that, to not actually enforce it would be an injustice.
Professor?
Yes.
Thank you.
I didn't catch this one thing. We're talking about like these three things. The first one was the by assignment. The second thing, I couldn't catch what was the second and third thing that we were
Sure.
talking
Hold
about.
on. Let me go back to my notes. Oh, assignment, delegation of duties. It's how you assign, like when there's a third party contract. It's with an assignment, a delegation of duties, or express terms in the contract for a third party. These are the ways that you can have a third party in a contract.
Third party, you mean include someone in the contract or?
Correct. Yeah, a third
Oh, okay.
person in there, a third entity.
All right, thank you.
You're welcome. Anybody else? Going once? Going twice? Okay, good night. Good luck next week on your exam. It's also going to be open book, 20 questions, multiple choice, 10 true and false, and maybe a few, questions here and there for extra credit. Okay? Any questions, you can email me during the week. How many hours you're going to have I think it's like 150 minutes, so it's like 2 hours and change to complete it. I think 2.5 hours I give you.
Thank you. Have a good night.
You're welcome. Good night.
Good night.
I have a
Good night.
question.
Sure.
Do I have to send you an email again for extra time?
No, I have you listed on my thing.
Okay, thank you.
You're welcome.
Good night.
Good night.